Good morning, everyone.
Good morning, sir.
Good morning, sir.
Good morning,
Good morning,
sir.
Good morning. Now, we are going to start our lecture now. I've given you 5 minutes to try to settle in. I'm seeing we have about 35 or thereabouts of about 35 students currently viewing. So we'll go straight to our lecture for today. Now, it's a lecture that's divided basically into 2 parts. The first part will be globalization of legal education. And the second half of the lecture will be focused on, as a legal practitioner, how do you mobilize for social change? I think this is very important, particularly in respect of some of you that I think will be dealing with rights, human rights issues, and also other issues. The problem normally will be, as a human rights lawyer, how do we develop and design test cases to pursue so that we can change society one way or the other? Now, a lot of rights issues have evolved in Nigeria over time, where lawyers have been absolutely active in terms of how those rights issues were changed. You remember that there was a time in Nigeria that the government just will come out and specify how many numbers of parties that the country will have for the electoral processes. And we found out that that was wrong and unconstitutional. And Gani Fawehinmi, senior advocate of Nigeria, was able to win a case that assisted in terms of us having a proliferation of political parties where citizens could feel connected to specific political parties, as is done in other climes. Now, obviously, there will be 2, 3, maybe 4 major political parties, and there will be other political parties that will just be focused on specific issues. There are green parties, for example, that will be focused on the environment. There are some that will just be focused on development and all that. And what that did was to change the establishment, the whole status of things relating to electoral law and other electoral practices. So our first part will deal specifically with globalization of legal education. And our second part will be dealing with how lawyers mobilize for social change and what are the things that lawyers should consider and how power can shift in respect of lawyers winning social change matters in court. I hope we are okay with that.
Yes, sir.
Okay, because for me, when someone talks about a law course titled Law and Social Change, my focus ordinarily, and I think the focus of most of us, will be to think about things that are, well, among law and social, other than just viewing social change and trying to acknowledge that there are some specific change in the trajectory of society. We must also be able to be at the vanguard of that trajectory, of that change, where we can come out with philosophies and ideas, not just for now, but for the future. Because the future is probably even more important in terms of law being ready for how it accesses the future. And as the future change, how the law, how lawyers, legislation, jurisdictions, legal systems, both internal and external, should be prepared for those changes. And not just that they are prepared for those changes, they actually can be the mobilizers for those changes. So our focus today will be legal education. Now I'm going to share a slide with you, and then we are going to continue with our interaction thereafter. Okay, my first question will be, when you talk about globalization. What do you think it means?
Sorry, sir, please can you come again with that question?
Yes, sir. Globalization, in a simple term, it means increase relationship or connections between peoples or countries.
Thank you. Anybody else? There's somebody scribbling on this screen, and it keeps happening. I don't know how the hell it happens. Whoever that is, please just take your hand off your screen, okay? Because I think you're somehow getting access to the screen without me authorizing you. Theophilus, go on. Class rep, globalization.
My mic was muted. Sorry, sir. For me, globalization is basically the process by which certain things, such as businesses, organization, or issues, for example, certain legal issues or certain humanitarian issues, are taken out of, not taken out, but are expanded more to become more of an international issue than an issue that a domestic government faces alone. So, for example, something like how human rights has come into the international phase, or how environmental law is more international, or let's say something like cyberspace or law of space, etc. These are things that have been made more international. So those are things that globalization handles. Things like war become more international and become more of a global issue than the domestic issue alone.
Okay, thank you. So when we say the world is a global village, can you situate that statement within the whole idea of globalization? It could be anybody. I just need the response.
Yes, sir.
Tunji, go on. Tunji, go on. Why is the world a global village?
Hello, sir. This is Adrash.
Okay, go on.
All right, sir. Yeah.
The world is a global village because one way or the other, the world connects by certain way of communication, either by trade, by international agreements, or by businesses, or even human
or even human
resources, sir.
Okay, thank you. We can leave it at that. Now, globalization has set upon us in the world, and some of us still talk about globalization as if it's a futuristic thing, while it's in fact something that has been happening for a while and is currently happening. And each time sovereign nations try to stop the effect of globalization, they are hit with even greater impact than they thought was possible. For example, we have the banning of Twitter in Nigeria, and people are using VPNs to access Twitter, right? And what globalization basically does, there are Nigerians who have foreign accounts, and when they come to Nigeria, they need to access their foreign accounts online. There are security measures for them not to be able to access their accounts online. They use VPNs to access those foreign accounts. You have traders, for example, in Kenya, trading and selling goods to people in China, in the US, and all that. You have the cassava farmer in Nigeria who is doing that, and a lot of these things are being done. A lot of the transactions are being done online, going across domestic borders and boundaries. And increasingly, you have, somebody came out the other time and they were talking about people beginning to have an overall internet time. You have things like Bitcoin, Ethereum, right? You are beginning to have cyber currencies, and at some point in time, you start having things that are considered to be cyber citizenship. Now, the question is, the rest of the world is awash with the impact of globalization. And not just the rest of the world. You talk about professional bodies. There are professional bodies that have started. They were always well suited for a globalized world. And many of those professional certifications that people have had over time, things such as the International Chartered Accountancy, what is it, ICANN? I think you have about 2 or 3 types now that deal with that. You have the chartered secretaries, you have for engineers, for all kinds of professional certifications that are international. And my thinking was always, those are the kind of certifications that are primed and are ready for getting access to the global market. I'll tell you a story of a friend of mine. There was an old professional footballer. That was when we came straight out of law school. He was an old professional. There was a professional footballer. They were childhood friends. The professional footballer was going to play football in Germany. And he called this my friend and said, there are some agreements I have to sign. I do not trust them. I'm going to transcribe them into German language and send them to you. He sent them to him. And the guy said there are certain things he needs to find out about German law. And he flew him all the way to Berlin to take a look at German law, give him advice. Why? Because this was the only person he could trust to give him adequate legal advice. Now, this is a precursor for some kind of globalization of the services of legal practitioners, because it showed clearly that the mantra we talk about when we talk about constitutional reasons, constitutional basis for fair hearing, for example, is that a man shall have the right to represent himself, or his counsel of his own choice, right, should represent him.
Yes. Yes, sir.
And within the African continent, we have found out that there are probably more Nigerians in the academia outside of Nigeria than any other country. What that shows us is that we have a market that is much larger in terms of a globalized world, in terms of our participation in a globalized world, than other countries have. You go to countries like Sierra Leone, there were countries where the Attorney General of that country in Africa will be a Nigerian. And it's happened over and over and over again. So we looked at the capacity Nigeria has to take advantage of globalization and the capacity the Nigerian lawyer has to take care of globalization. And the idea came into being of whether, as a matter of fact, because some of the things that militate against globalization of legal services, for example, will be certification processes, which are proudly and strictly domestic, right? If you remember the case of Awolowo versus, who remembers the case of Awolowo versus Federal Minister for Internal Affairs?
We do, sir. Yes, yes, sir.
Let somebody just summarize it for us, please.
Part of the issues I remember in that case, sir, was that there's a lawyer from overseas who wants to represent Awolowo, but the lawyer was denied access to enter Nigeria, and he wasn't allowed to represent him on the ground that probably he has not done the necessaries for him to come to Nigeria.
Okay. Now, Awolowo at the time was charged with treason. And he decided that there was, I think, some Mr. Gracia or something, I've forgotten his name, who was a British citizen and a British practicing lawyer. And he said that was the person he wanted to represent him. On he trying to gain access into Nigeria, the Minister for Internal Affairs deprived him of access into the country. The Minister for Internal Affairs was the defendant in that particular case, and Awolowo sued, saying he was being deprived his constitutional right of having a lawyer, a representative of his own choice. right? And the judgment was to the fact that the representative of his own choice, as enshrined, I think, in the under the fair hearing provisions of the 1960 Constitution, would be a legal practitioner of his own choice that is entitled to enter Nigeria as of right and practice in Nigeria. Now, this shows us clearly that the representative of your own choice is limited in terms of, now my friend who followed his friend to Germany to go and look at legal papers did that unofficially, not officially. Why? He couldn't practice in Germany. He did not have German certification to practice. So because of that, even though the only human being this person trusted was a Nigerian, he could basically not have a representative of his own choice. He was forced to be represented by other people because of the issue of certification. So the question now was, if lawyers could have global certification in the same manner that, say, chartered accountants can have, in the same manner, for example, that chartered secretaries can have, in the same manner that some other professions can have, then you are looking at Nigeria having a capacity well beyond other African nations, particularly in the legal profession. And we ask ourselves whether this will open up the country and its legal practitioners to newer opportunities in a globalized world. So, which is why I said, for me, jurisprudence, law and social change, we should be focused on concepts, not just concepts for now, but concepts for the future. Because we ask ourselves, and a lot of people, you ask this question and say, it is impossible. Because of what? Because of several reasons, obviously. There's sovereignty issues, there are certification issues, there are standardization issues, there are all kinds of issues. But we choose to look at those issues and also look at the gains for both the profession and the continent and the larger world itself. There was a time people thought that the European Union could not happen. The European Union happened. There were also times that the NAFTA treaty, US and other countries, that couldn't happen. But we found out that protectionism is the great antithesis, is the great antithesis to globalization and standardization of products. We've also looked at it, and we took a look at the African continent, for example. In May 2020, I think the African Continental Free Trade Area came into being. Now, a lot, I think about 53 out of the 54 countries of the African Union have agreed basically to it. Nigeria was a late arrival, and I think just about 30-something would have ratified the ACFCTA treaty. Now, Nigeria came as a late starter for several reasons. And they came as a late starter to that agreement because of the rules related to the origin of produce. And they were scared that Nigeria would be suffused by cheaper products from other African countries, which is counterintuitive in the sense that we always felt that if there was a continental free trade area, Nigerian goods will take over, basically because of our capacity in terms of our productions, our manufacturers, and the services that could be rendered. But we are seeing a difference now, because what it meant was for Nigeria to be a little squeamish about entering into the treaty. It meant that the government was afraid that our manufacturers and our producers may not have the capacity to compete in terms of pricing. I hope we are getting it.
Yes, sir.
So if you cannot compete in terms of pricing, in terms of standard of goods and all that, it meant, and it was the same problem America had before the NAFTA treaty with Mexico. The fear was that the goods coming in through the border across in other North American countries will be cheaper than American products. Why? Because America had a very serious, they had serious trade laws, issues relating to workplace standards, what happens in the factories and all that. And all these escalate the price of produce emanating from all those factories. Now, for us as lawyers, we've taken notice of certain things that happen, and some of them are here, which meant that globalization, having a kind of global village where there is very little boundary restrictions to goods and services, also meant that there will be rising income and larger economical gaps. For the people like George Soros, for example, who had control over foreign exchange dealings and all that, he will be much richer. For people who do not have an understanding of what globalization means and their place in it, there will be a wider gap because they will get poorer. And that there will be demise of law, language, and culture and ethical practices. When globalization just started, globalization obviously has started before the internet came into being. The process was already on. But when the internet came into being, some of the things we understood were changing. In terms of our language, LOL began to mean laugh out loud. And we were using it. The first time I saw LOL on my terminal, I didn't know what it meant. But there has been a change of things in terms of awareness. The language is changing, ethical practices are changing, culture is changing. There was a demise of law, and I'll tell you why. You go onto the internet and look, if you go into the internet, for example, and you look for an agreement on conveyance in our assignment, you are likely to get an agreement from the US, from the UK, maybe Croatia, not Nigeria. And you use that format you could use that format for your client in the office, not understanding that there are some specific words and specific phrases that connote specific meanings to specific specific legal systems. An example could be something like unexpired residue in Nigeria, which means something very specific. So there was a demise of law because there was beginning to be a merger of law and legal principles that even lawyers that were practicing were not taking very good cognizance of. And also there was technological fragility. And technological fragility meant that poorer countries with frailties in terms of technology will suffer, and there will even be a wider gap in terms of rich-poor nations. And within the country, a wider gap between the upper financial class people and the lower ones. And then there was rising nationalism, populism, and conflicts because of instances of cultural appropriation. People started to look at things that you had the Chinese now beginning to do gari and packaging it and selling back to Nigerians. The very first time that happened was when a Nigerian engineer came out with an electronic pounding machine. And a company, I think called National, took it to Japan, redid it and mass produced it and sold it back to Nigerians. That was the first inkling that we should have had. Nobody noticed. Now, it's changing because the other day we found the Ghanaians, who were probably the kings of cocoa production and big voices in the production of chocolates in the world, were complaining why the Chinese and every other person has started producing cocoa at a level that was before known, that was unknown before. And you are beginning to find a changing in the marketplace. People producing produce that they were not naturally known for. Why? Because of increasing capacities, because of globalization, and also increasing knowledge. You will find out that whoever is producing cocoa, the first set of consultants for the cocoa production will probably be citizens of Ghana, transported there, being paid maybe some $3,000-4,000 per month. And then when the production is situated in the country, they tell you to go back to your country. And then, so globalization brought, and because of this, there were nationalist fathers in terms of protection of things that belong to us, not just things that belong to us in terms of just technology, food production and all that, but also in terms of the psychology. Where if someone, for example, were to have, if Caucasian women, for example, celebrities, plait their hair in braids and cornrows, they call it cornrows there, we call it braids here, they will be accused of cultural appropriation. You are appropriating something that belongs to our culture. So these are some of the things that globalization brought into play. Obviously, there are environmental risks because you find mining and all that being done by non-citizens who just at the end of the event pack up and leave you with the environmental degradation. That is happening. You are finding, again, the weakening of global corporations in some areas, in things like, there's a strengthening of global corporations in things like delivery and distribution. AliExpress, probably over the last 5 years, has made more money than it ever did. That is the reason Jeff Bezos is one of the richest people in the world, because of Amazon's delivery networks and capacity. And you find out that a lot of things, especially during the lockdown, while the aviation industry was teetering on the edge of collapse, you found out that people like the Amazons and the other delivery, because they were the ones delivering food and delivering services to homes during the lockdown, nobody could move out of their homes. And those companies made more money and gained more influence than any other type of company. Now, all these things are things that globalization has to address. And as globalization is trying to address that, the key question will be, number one, if the market economy views, because we are talking about globalization, but our focus is on us as legal practitioners and on you as students who will be legal practitioners in the next 1-2 years. And the question is, if the market economy views legal practitioners with global perspective and training as more efficient in legal practice, will they be valued more? If you have more training in and you have a better global perspective, will law firms and other businesses value you more?
Yes, sir.
Because it's an added capacity, and it's a capacity that is required for the legal practitioner now who has ideas of operating in a global world where your competition is not your classmate, but the man from Yale University and the legal practitioner from China. They are your competition in a global world. Now, again, it means that students, the market economy is focused on students. Initially, legal education was dislocated from its environment. There was a specific traditional way of training people in a legal education. Nobody was focused in terms of what the society actually needs or requires. Now, our societies are changing so fast, and the education of the lawyer, our curriculums must take note of the. I remember a former DG of the law school talking about Nigerian faculties having an average of about 22 courses per tenure. That is whether it's a 5-year tenure or a 4-year tenure for the undergraduate studies, and compared it to an American, to the average in an American university of probably about 70-something courses that are being taught. in the undergraduate tenure for students. And he said the difference was most of the added courses were global education based. So that means that if you are not having your education in terms of a global world, what is going to happen is that your services, your expertise will not be required outside of the little domestic practices in the country. So because of that, your training is supposed to have global perspectives. Now, somebody called Javier De Sandra, I think he's the coordinator of the World Justice Program now. And what he said in respect of global education for lawyers. Okay, Abdul Rashid.
Thank you very much, sir. Now, we are talking about the fact that maybe Nigerian law students have been deficient in terms of global education, global legal education. Now, I do not feel at this time that the issue of curriculum should be the fulcrum or should be the main point of globalization in terms of legal services. I believe it should be the issue of making it possible in the first place. Just like you have made us understood this morning in the case of Awolowo against Minister of Internal Affairs, it's not even possible without for having a system whereby lawyers from around the world can just walk into a country and practice. I believe that should be the first thing that we look into. Then after that, we talk about curriculum and all.
Okay. I understand. But you know, who is the second participant raising the hand? Aziz, let me hear your own perspective.
Good morning, sir.
Good morning.
Oh,
I can't hear you.
we can't hear you too.
Can you hear me?
In USA court or United Kingdom court and practice law, which is not being taught in the law schools, because there's no how a Nigerian lawyers will walk to any other court in another jurisdiction to practice law. So the first thing to be said is that we have to review the curriculum in our law schools before, because the knowledge supposed to precede practice. It is when you have the knowledge before you can practice. If you don't have the knowledge, you can't practice the law in law court. That's my stance, sir.
Thank you. Aziz. Okay, it was Aziz that spoke just now, right?
Yes, sir.
Okay, Mustafa Adetoyebi.
All right, sir. The issue of whether we are going to amend our curriculum or not is not even an issue now, because whether we amend curriculum or not, the issue of globalization of legal services has come to Nigeria and it has come to stay. Now, a lot of big businesses are beginning to hire lawyers from around the world, not even Nigerian lawyers, especially when it comes to the issue of advisory. Because from what my friend said, Aziz, that you cannot practice in another country's courts. Litigation is not the only area of practice for lawyers. There are other areas, especially advisory, and that is where the big money is really now. Now, people are beginning to hire lawyers. Even Nigerian business are beginning to hire lawyers from across the world because of the belief that, quote and unquote, that Nigerian lawyers are not prepared for that particular service, to render the particular service. So it is now an issue of whether we want to, it is not really an issue of whether we want to amend our curriculum or not. Even if we don't amend our curriculum, people are beginning to learn things online. Education has become so easy that you can just find anything online, read, or even take basic research online to advise someone that is not in Nigeria, maybe someone that is in London, on a particular issue which he needs to be advised on. Thank you, sir.
Thank you very much. Now,
Yes, sir.
Tunji, okay.
Yes, sir. Thank you very much, sir. Although my network here is not that good, so I did not hear your question from the beginning, but from their discussions, I have fathomed what we are talking about. And my stand is that I want to align myself with what Aziz said. If you are saying we don't need to change our curriculum, like we don't need to amend our curriculum, it's as though we are trying to deceive ourselves. We are saying we want globalization, or that globalization has come already. How are we going to fit in? What we have now cannot make us to fit into the system. So we have to have something in order to make ourselves fit into the system. So we need to amend our curriculum to fit the connotation of globalization itself. If we cannot, if we are not prepared, like we don't have anything to prepare us now to fit into that system, then there is no need to talk about practicing it. That is my first stand. The second thing is that if globalization could pay us as Nigerians, that is, we may be valued in other countries. I believe there is this nature of Nigerians that they even value foreigners more, even if we have the same thing that those foreigners have. I believe the Nigerian factor, or the Nigerian, I don't know, the kind of nature that we have in this country, whereby our people value what is foreigners, or what is foreign to what is local, will also be a factor. So that is just from my own perspective, sir.
Okay. Now let's keep the arguments going. You can use the chat section of Zoom to keep the talk going. Now, a lot of things that have happened, and I can, from different perspectives, I probably will agree with both of you, which is a very confusing thing to say. But obviously, capacity is very important. But what I always say is, if the certification issues are dealt with in terms of this is the process now, if you want to do this, I think the capacity becomes much easier an obstacle to cross. Because people talk about us not having capacity, not having this, not having that. And you find the majority of Nigerians that do the Chartered Institute of whatever exam will pass those exams, right? We have students with you there who by their second or third year would have passed one professional exam or the other. And it could be a professional exam that is not even related to the specific courses that they are doing in within the tertiary institution. So if there are, capacity is something that you build over time. But if there are rules and regulations relating to, okay, if it's this particular type of practice you are doing, and you can go through certification or giving a temporary certification under certain limitations of practice or whatever, people, like the guy said, people are already doing advisories, consultancy. I have consulted for people in the US, Nigerians that went to the US who did not want to deal with Nigerian lawyers, and they sent me a US agreement and I consulted over it. And I think most of you probably will end up doing exactly the same thing. Now, the problem now is what the market will find whatever it requires. The problem is Nigeria ready to provide that market before legal practitioners from other countries take it away? And fine, in terms of capacity building, it starts from our schools and our curriculums and all that. But we have people complaining about what is happening in the primary education sector. And because of that, there's a spin-off into what will happen in the secondary education sector. And because of that, again, there's a further spin-off of what is happening in the tertiary education sector, which means we have what some people say is a degradation of the standard of education over time. You have an admissions process that is fraught with problems. And if you live in a society where certification takes more precedence than actual knowledge in terms of the content of your knowledge, then you are going to have great issues. But in principle, those issues, these great issues that we talk about, cannot be impossible to trounce. Because once we start looking at what are the principles, what are the challenges that we have, is this one, how important is this challenge? And then we can enumerate them in terms of areas of importance or priority. My mind is set that there can always be ways out of that. As a matter of fact, a futurist looked at the world and said a time will come when the world will have just one president. And countries may turn into states. Is that possible?
I agree, sir.
So we have people who look at it and they say, okay, because a time will come where nations will say we want to join this mega nation. And it basically happened with the EU, because you had an EU parliament, you have an EU head, you had elections, EU elections being held in other places. Now that Britain has left the EU, and the EU did that to be able to compete with the Americans by bringing resources and thinking together. And increasingly in the world, you will find out that there's a specific need for capacities in certain areas. Our question is, can we have a global law school? If we have a global law school, whether it's possible or not, what are the challenges that stand before a global law school? What are the things that we gain if we have a global law school? And if there's a global, if we have some kind of global law school, is that not a compelling reason for standardization? I'll give you an example. If someone says, if you don't have online capacities like we are having now to take lectures and all that, can we have a universal law school where 5 million students, for example, will be taking lectures right now as we speak? If you are going to have challenges with electricity and then all your students cannot key into that, then it means you are being left out of the race for global participation. So because of that, it compels standardization. But let's leave that. Let's read Javia's statement. And he says, increased globalization. Sorry, can someone read it for us?
Increased global competition, increased students and faculty mobility facilitate the search for excellence, which in turn promotes the creation of leading global education hubs in those countries and regions most able to generate them. These hubs are best placed to attract the best and brightest students, faculty, and resources, generating, in turn, top graduates, research outputs, university spin-offs, and so on. At the same time, these shifts risk leaving many education institutions lagging behind, sometimes through no fault of their own, with attendant negative impacts for their stakeholders.
And in a way, this is a warning for countries that think that there should be no processes. Because if you are not able to capacitate your students, then what it means is your students will be left behind. I was at a presentation ceremony of a Nigerian firm which handled some of the energy privatization agreements. And that firm was a Nigerian firm, but had a legal practitioner in our presence, had a legal practitioner from the UK, one from the UK, and another one from Pakistan. Of course, they couldn't practice in Nigeria officially, but they were acting as consultants, giving advisories to this person, and they formed what you call a mega law firm. If you look at the classification of mega law firms in the world, you will not find one Nigerian law firm there. Most of the mega law firms will come from the United Kingdom and the United States. And when you look at the market, you will find that Nigeria is slightly overrepresented in the market in relationship with the so-called mega law firms that we do not have. What that tells you is some other layers, for lack of a better phrase, are eating your money. And what do we need to do to bridge this gap? And you ask yourself, why is there a need in the first place? The market is there. The corporations are there. The required services are there. Of course, there are needs because the global justice system, when you talk about education, education is the greatest and most potent aggregator of wealth. And when I talk about education, we are roughly talking about Western education. There are other types of education. Let's just have that in mind. Now, we talked about education being the most potent aggregator of wealth. Education doesn't necessarily mean Western education, even though that is the example we are giving. There are other types of education. If you look at the Igbo apprenticeship system, that is education. Because the apprentice is being taught in the skills of trading. And across the world, that is the most unique aggregator of wealth that is designed in that manner. Why? Because when the apprentice finishes his education, he's not just left like other educational systems with an empty hand. His boss, his oga, has to settle him by giving him money to start his own business and giving him some of his network as customers to start with. And that is how most families in the East, for example, moved out of poverty to wealth. And this is a unique system in the world. Now, that is education. And we say education is one of the greatest, most potent aggregator of wealth. Now, again, we talked about the choice of a legal practitioner of one's choice, which is as noble a pursuit as any. And in the world too, there is a deepening of global legal knowledge. A lot of people, I'm not sure there's anything in Nigeria that has made us, in terms of administration of justice, has made us use the polygraph test, for example. But we are aware of the polygraph test and we have learned the pitfalls or whatever of the polygraph test and why it's not used legally, but used administratively. It is a deepening of our knowledge. And there is a deepening of other types of knowledge because of our access to documentation and all that from other countries. Most of us watch the Derek Chauvin trial on TV, right? Hello?
Yes, sir, we are with you, sir.
Okay, how many people watch the Derek Chauvin trial on TV? That's the man that killed Floyd with by kneeling down on his neck. Did you watch it? But again, there are other trials over the years that people have watched. Ted Bundy, the serial killer, was the first nationally televised trial in the US of a criminal, I think probably of a criminal proceeding. A lot of people watched that. A lot of people watched the O.J. Simpson trial, for example, where the catchphrase there was, if the glove doesn't fit, then you must acquit, right? You can Google that and take a look at that. But the point I mean is you have Nigerian lawyers beginning to have access to resources that they didn't have before. And because of that globalization, there's a deepening of legal knowledge. And also that leads to a development and standardization of legal practices where basic things such as arbitration, agency, and all that become almost some kind of international affair for all lawyers across all countries. And then you have increase in competition by the increasing capacity of regulatory bodies and blending of rules of regulations across, because there are certain rules that you see in one country and then someone will say, okay, we need this kind of rules in our own, for our own regulatory bodies to take care of. Now, again, in terms of funded research within the academia, people need research of global relevance and not just local relevance. So the money is moving towards things of global relevance rather than local relevance. I'm just showing you the need, why we need to catch the bus before it takes off. Now, there's also a need to create practice-ready graduates in a global environment. When you look at our medical students, the moment they leave our medical school, from the get-go, there are certain things they can do. They can practically almost do everything a general practitioner can do. They can take care of your malaria. They can take care of basic things, high blood pressure. They can prescribe and do certain things. But most law students, when they leave our faculties of law, only can draft the most basic of all legal documents, will be an affidavit, for example. You will only be able to look at the elements of drafting an affidavit when you get to the law school. The only time you can get a glimpse of that will probably be at 400 level, where you did your mock and your mock trials. Now, this is not good enough if we are trying to practice in a global market. And again, there has to be a bridging of the gap between teaching in traditional methods and then using technology. We are using some level of technology now. In the days preceding the lockdown, there wasn't this level of sensitization relating to technology, the use of the deployment of technology. Now, other than just the deployment of technology and traditional teaching methods, there are also, as traditional practice changes, students must change. Even students who envisage a practice that may not be global in perspective must change. Now, what are the challenges? Because we started off by talking about the challenges when we're talking about whether there was a need for a curriculum amendments, whether which comes before the other, very much like the chicken and the egg thing. Does the chicken come before the egg, or the egg comes before the chicken? And we were having that discussion relating to there must be capacity first, then before the changing of the processes for certification. And some people say if the processes for certification is changed, then there will be a buildup of capacity to meet those standards that are required. But some of the challenges, for example, particularly pre-internationalization challenges, when you're thinking of merging your educational system with that of other countries, will be number one, institutional trust. I hope you are still with me.
Yes, sir.
Yes, sir.
When we say institutional trust, who can give us a brief summary of institutional trust? What do we mean? Hello? Tunji,
From what
can you
I
help us?
understand, sir.
You said what?
Yes, I did not hear the question. I wanted to say, I did not hear the question. I wanted to say if you can repeat the question, sir.
Okay, when we say institutional trust, you know, pre-internalization challenges means before we start talking about globalization, there are some challenges we may have. And one of them is institutional trust. What do we mean?
Let me just say basic.
Okay.
All right, sir. From what I understand by institutional trust, it means the belief in the maybe regulatory authorities with respect to certification.
Institutional trust is basically two. You've taken care of one, the regulatory authorities. When people are talking about certification, when they say, for example, this is the curriculum that the NUC has approved, are you sticking to it or not? So you talk about the regulatory authorities, whether it's NUC, whether it is the Council of Legal Education. Then you also talk about the faculties, the universities that house these faculties. If someone, for example, says you are supposed to have a lecture, you are supposed to have a 15-week lecture date to study so and so, are you sticking to that or not? Who are the people teaching these things? Do they have the capacity to teach it? Who are the students that you are teaching to? Did they follow the normal JAMB requirement to get admitted into the university to study this particular course? And if they do, then has the period been consistent? The period of learning. And I say this because you are just coming off a 1-year ASU strike, right?
Yes, sir.
Yes, sir.
Yes,
so
sir.
will countries from other, will institutions from other countries that form the group for certification, will they trust you?
No.
They may not, sir.
They may not. You understand? Which means it's a challenge, but it is again not a challenge that is insurmountable. You can have discussions. You can talk to ASU, for example, and say, look, this is the particular agreement we have entered into. This is what we must do. This is what we must do. This is what we must do. You know? Now, the issue of institutional trust is there. There's also the whole idea of having this, somebody was talking about Nigerians would normally believe that anything that is foreign is better, right? If that is true, then the next point talks to that, the next heading talks to that point. That is neocolonialism, or at best monoculturalism. You can have a neocolonial mindset where, for example, your colonial masters or whoever is the country that you look up to begins to devolve regulations to you without participation from you. Because in international diplomacy, whoever has the power will dictate. And they will have the power in terms of the capacity. And they will dictate in terms of what they think are the levels of standardization that are required. And this can lead to monoculturalism. What monoculturalism means is Nigeria may have its own tradition of legal practices, but that tradition may be subdued and it may differ to that of a higher power, so to say. Why? Because they will dominate the discussion. There's also the issue of state sovereignty. And I say this to my international class, each time there's a bilateral or a multilateral agreement or some kind of protocol or convention entered into, states cede some of their sovereignty. Because you are saying, I'm now part of a group. And being part of a group basically means that you can't behave as an individual state, even though we continue to pervade the whole idea of state sovereignty. And the concept we have in our heads means that we're talking about things like certification to practice, which normally only one state will give its citizens based on certain regulations and criteria. Now that has to be opened up. If you open it up and people from Cameroon or some other countries, some of them may not even speak English, may come in terms of a global practice and require not just witnesses, will now require interpreters. You have lawyers from other countries requiring interpreters. Is that difficult or not?
It is very difficult.
Then we have immigration issues. We talked about the Awolowo matter and all that. And immigration issues, basically, which is the height really of state sovereignty and may very well be subsumed under sovereignty. But immigration issues basically is a country having the right to dictate who enters into its country and who does not enter. The only person Nigeria cannot stop from entering Nigeria in the international realm is a Nigerian who is a citizen by birth. So while the Minister for Internal Affairs was well within his rights in stopping Chief Awolowo's lawyer from coming into the country, if that were to happen 2, 3, 4 times in respect of legal practitioners, while we are trying to push for a global practice, then it means that those are also issues that have to be addressed. Now, people talked about dual accreditation as a precursor to a global law school. And by dual accreditation, I mean Nigeria, for example, saying a university in Nigeria could say, we are working with a university in so and so country. And then they come together to set up law courses and whatever. And both students will agree to go to, it could be the Nigerian law school, it could be the Malaysian law school or wherever. And then, but when they graduate from the undergraduate level, you are talking about double certification. That is already happening in a lot of other fields, particularly some of our students that go for undergraduate studies in countries like Malaysia, Cyprus, Turkey, and all that. There are already agreements in place that assist for double certification, which means you are certified to try to do whatever in both countries. But again, for that, again, it will also require you perhaps to go to the different law schools of both countries, which is a very difficult outcome. Then we talk about our undergraduate and law school curricula. We talk about inexperienced, sometimes uncommitted law lecturers. There are other issues relating to general depreciation in training and morals among everybody generally, particularly in the academia. Then you have inadequate funding of law programs in faculties of law. And I'll tell you why there may be inadequate funding of law programs in faculties of law. Even when you are looking for grants and all that, people are looking for products accompanying the grants they are giving you. So for those in law, in the humanities generally, to have a specific product is much more difficult than for those in the sciences. And because of that, you have less access to funding than people in the sciences, for example, will have. You can imagine the amount of access to funding for investigation into the COVID-19 that was happening. How much of that did you think went into law faculties? None.
Nothing.
So all those are issues. Isha Kruka, I think you're the one that's scribbling across our presentation. Now, there are also inadequate infrastructural facilities, limited access to digital resources. I went to a university in the US that was using 100% digital resources. And it was a Nigerian that coordinated that effort. Now, there are also issues relating to brain drain. For a lot of faculties in Africa, their first port of call are Nigerian academics. It's happening in Ghana, it's happening in Sierra Leone, it's happening in Rwanda right now as we speak. It's happening everywhere. So if you have the issue of brain drain, while you can have more presence internationally, it actually creates a gap in local learning because some of your best people will be moving to other places to for a better life, so to say. Now, we have strikes, which is also a challenge. We have unstable criteria for examining students and examining the examination and for the examination of students. All those are problems that are challenges to even dual accreditation as a precursor to a global law school. Then interference with legal education by governments. And this is very simple to understand because take, for example, JAMB will tell you how many people you can, the advice relating to the minimum score. There was a time, I think it was 180 in JAMB. And you find people telling you that whoever has 180 in JAMB should just go to a technical college or something. You know, and governments will say, no, there are places for, there should be placements for, and then when you find out in some places, the actual, you can have in an area where somebody with 180 may be studying law. In another area, someone with 260 cannot study law. So you have interference in terms of policy. And while the Council of Legal Education is there, you have also the NUC overlooking general tertiary education. And their policies may not always be the same. There are general challenges too. You know, we've spoken about, and I think this is just a rehash of some of the things we have spoken about, just so that it can be imprinted in our heads. The whole idea of nationalism, people just believing that we have a specific way, a specific culture, tradition of doing things, and then we love our country. Our country is the best in the world. Well, if we are in a group with other countries doing the same thing and having the same certification, we will not be able to say we are the best in the world anymore. Because you have assimilated into a group. Two, the traditions of legal practice in different countries differ. There are countries that are basically Islamic practice in terms of law. Saudi Arabia, for example. How do you assimilate it into a group that is steeped under common law or civil law across the whole of Europe? Obviously, too, there are inherent capacities of schools and regions. As we are talking online, there are countries that cannot even have a lecture online. Why? Because the capacity does not exist. With all your complaints about electricity in Nigeria, there are countries Nigeria supplies electricity to. And there's an expectation that those students in those countries will also be part of the group. Then there is the issue of citizenship and jurisdiction, obviously. Will citizenship be relaxed, specifically for legal practitioners? In the same manner, citizenship and entry issues are relaxed for, in Croatia, for example, if you have special skills, a lot of Brazilians became Croatians by being able to play football well. Will countries agree that things like law and legal practitioners, because of their specific quality of being representatives of citizens, be given a special pass in terms of entry and in terms of citizenship? And there are regulatory bodies too that are protecting themselves. If we have a general regulatory body, will I, as the head of the regulatory body in Nigeria, Ghana, Sierra Leone, will I not be out of a job? Or just become a simple coordinator for my country? Among what? Maybe 70-something or 90-something coordinators. There are also training and personnel needs. There are training in terms of certain things. How do we talk to each other? Are the processes in a Nigerian law court the same as the processes in a Czechoslovakian law court? Other than that, there are also challenges with abstraction and simplification. When we talk, for example, about abstraction, we talk about what are general principles in constitutional law, for example. If we talk about what are general rules in constitutional law, can that be abstracted across jurisdictions? Are they the same? While they may not be the same, the question remains, will I, for example, as a Nigerian practicing lawyer, be able to understand the nuances of the American Constitution? And if I do not understand it, does it matter? If a client there says whether he understands it or not, he is the one I want to represent me. Now, the way to strategize is this. The first thing is that there should be political will, which is always, of course, will is the first thing in everything. That there must be that will to surmount these challenges we have listed. That professional certification, for example, you can look at other professional bodies and look at how they have been able to handle the issues of professional certification, e.g. for accountants, for arbitrators, for chartered secretaries and all that. And two, that there are ways to set up multicultural classrooms. I went to the US for a seminar once, and a Canadian invited me to lecture her students. And she said, we'll either pay for your flight or you do it online. I don't agree with your legal pluralism ideas, but I think those ideas are ideas my students have to have access to, because I say different things that are different from you. So because of that, you can have multicultural classrooms in terms of dissemination of information and knowledge, but also in terms of certification. And there's a model. The New York University and the National University of Singapore did something in that regard. And it was a model for other countries to follow. And particularly in other areas like pharmacy, business studies and all that. It has already taking root in a lot of countries. And then we need active learning modes or methods, interactive classes, ways of testing students. I had a discussion with a lecturer in the UK who said they had about 10 or so ways of testing students, and somebody else in the US said they had so number of ways of testing students. Why? Because of the system of in law schools. Why? Because of the systems that they practice. Where in the US or UK, where you may have a jury system, the way of testing students may differ from Nigeria, where you have a sole judge that is sitting. Human gestures may become important. Body language can become very important. Even dressing can become absolutely important if you are dealing with jurors. If you are dealing with a sole sitting judge, you expect that he can go beyond all those representations and focus on the meat of the case. And then there has to be multidisciplinary learning. Again, comparative learning. People in one jurisdiction must be open to learning about the laws of other jurisdictions. There should be cooperation among law schools, and there should be law school mergers across jurisdictions. When you have mergers of corporations, it is so that they can become stronger. If, for example, we have a single legal jurisdiction in West Africa, for example, it will become a problem for people in East Africa because they will need something comparative. And then eventually there could be a merger of West and East, a merger of West and South, and then they keep morphing into larger groups to take care of the market that globalization has opened up. And then there may be new rules for law clinics. Our law clinic in our faculty is already doing a lot of work in terms of community services, advocacy in respect of freedom of information, the Freedom of Information Act, and all kinds of things, the congestion of prisons. We've been doing all that. Now, at the Department of Jurisprudence and International Law houses the Disability Rights Project for the faculty. And that is the first disability rights project in Nigeria, and may very well be the first in any West African university. Now, all these presupposes a new role. And law firms too must start to think in terms of a new role. Governmental organizations and non-governmental organizations also have to be in line with this process. And there are areas of immediate convergence to conclude. One of the areas of immediate convergence will be the area of international law, obviously. Jurisprudence, obviously. Legal theory, contract, commercial law, comparative law generally, maybe comparative constitutional law and all that. And those are areas that are already where the crux of learning is already largely the same across jurisdictions. So it can be a way to move forward in terms of using them as test cases for our projection for the future. And the argument is always, is all this possible? And we say you can answer questions with analogy by looking at other areas where there has been global cooperation to arrive at solutions to problems. I hope we're okay with that. Any comments?
Yes, sir. Thank you very much, sir. Now, on the question that is it possible, I believe it is possible if it is well planned and standardized. Now, if we look at medicine, for instance, now we have medical experts, professionals all over the world, and they can basically practice in any place around the world. So I believe it is also possible for legal practice to travel around the world. However, there are issues which I believe this particular presentation and lecture has taken care of, and we just need to ruminate over them, sir.
Thank you very much. Any other comment or observation?
Yes, sir. Thank you very much, sir. Hello,
Yes,
can you
sir.
hear me, sir?
I can hear you. Please go on.
All right, sir. Yes. Just like Abrashid said now, the lecture has actually covered most of the issues and challenges that I have highlighted here even before the lecture went into that direction. But I want to agree with you that the areas that we have highlighted at the conclusion of this lecture, they are actually possible, particularly contract and commercial law. I want to believe that the world is already tilting towards having something globalized or something that is very similar in terms of these two areas of law. So, but for the rest of them, or maybe yes, for the rest of them, there will still be need for some time before we can achieve our projection. So, for the rest of the areas, that's just my take, sir.
Now, thank you very much. We'll probably still have another time where we can have a general discussion relating to this. What I want to do now is for the second part of the lecture, quickly move to what I'll try to do is try to quickly move to the other screen so that we can quickly go through something else. Now, for this one, what we're talking about basically is we talked about basically a law and social change mantra is what we were doing. Now, if we talked about a law and social change mantra and everybody was focused on having some kind of access to, can there be a global legal practice or not, to fulfill certain ideals and certain needs and requirements. And we said Nigeria, particularly because of our capacity, will be best placed to enjoy access to this global certification, if any. Now, that is just one of thousands of law and social change issues that are there. There may be other change issues. Across Europe, we have seen the advocacy for feminism. And we have seen the advocacy for feminism come in even different other movements. Movements relating to equal wages for women, equal conjugal rights, things relating to abortion and the right to life, for example. Then it has morphed into the LGBTQ movement, which are all spin-offs from some of these. And it's important that we understand that some of these movements, some of these social change activities hardly happen randomly. People, we kind of sit down and then we think, okay, the Brown versus Board of Education, it was just someone who was sitting down somewhere and they said, you can't go to a particular school. And fine, you can't go to a particular school because of segregation and all that. But there were civil rights lawyers waiting for just that type of test case as a way of mobilizing social change. So the question now is, if you want to mobilize social change, mobilizing social change may not be global in terms of, say, what we just discussed about the global law school. It could be mobilization of just something happening in your community, mobilization for social change of something happening in your community. So there are three levels of mobilization. It could be local, it could be national, it could be international. But lawyers almost always have to be at the vanguard of these changes. Why? Because when change happens, there is also a switch in terms of the power equation. When Gani Fawehinmi went to court, I think, was it 1990 something or something, I've forgotten. When he went to court and he talked about that, the fact that the Electoral Commission did not have the power to talk about how many numbers of cases there are in this country. It was a social change movement. Why? Because for the first time in Nigeria, it was shown constitutionally that the kind of parameters that were set down for registration of parties were wrong, because it infracted on what? Your freedom of association. And because of that judgment, Nigeria had God knows how many political parties. There are also other social change issues that we have had over time. Some went to court, some did not. And again, it is not every social change issue that needs to go to court. Some social change issues can come by way of negotiation. Sometimes it can come by way of arbitration. So I'm just going to go through the process for you, for those of you that will be interested in law and social change, particularly the people that are focused on human rights issues. And we said the rise of empirical studies. Empirical studies is investigative studies into society. Has changed a lot of things in terms of how law was taught to be practiced, because initially law was isolated from the society, so to say. And it came with the monarchy basically saying this is the law and you follow it, no question. But over time, we found that there were investigations into society by legislatures to find out, and then in the process of enactment of laws, there were public hearings and first readings, second readings, and all these were advocated upon and made public. Why? Because that is the process that you use if you call yourself a representative democracy. But this also changed us in terms of how we think of the law. And how has law affected this change? There was the issue of evaluation. When we look at a problem, for example, how do we evaluate that problem? And in this regard, you found out that there was a lot of work done by the Sociological School of Jurisprudence to assist in this regard. But there are also other schools that forced us as lawyers into looking at society in a different way. We talked about the realist school, we talked about the critical legal studies. Currently in the US, some states are banning even literature by the critical race studies movement. Who said races, people see terms in terms of race as a group, and then they use it, laws are made in that regard to entrench the superiority of one race over the other so that they can have greater and better access to resources. And we look, because of that, we look at things in a different manner. While we may not have different races in Nigeria, we have different tribes in Nigeria. We have different social statuses in Nigeria. You have the politicians and the non-politicians. You have the economically rich and the economically poor. And all those form cliques within society in the battle for resources, or what in Nigeria we call the national cake. Then we also look at the effect of these social movements such as revolutions and representative democracy. And people say law is a power. I made a joke in class, I think last week or during the week, where we spoke about each time there's a revolution, the first people they go for are the politicians, then the religious people, then the lawyers and the judges. Why? Because these three sets of the people are the ones that are most pro-establishment in most societies. And because of that, we see law as being a power. A lot of ordinary citizens will see law as being a coercive force in the hands of the people that dictated the means of production and the income and whatever the resources in society. But again, if it's a power, the view for some lawyers is to see it as a power to institute social reform, a power to maintain, is it a power to maintain the status quo? As some lawyers see it.
It may be, sir.
What?
This may be so, sir.
It may be so.
Yes, sir.
Okay. Some people also see law as a power to hold authority figures fidelity to law, which basically is what I think people like Chief Ganifa and he may have spent his whole life doing. This is the law and you must follow it. Now, there are different ways for lawyers to mobilize for social change. One of the ways is what you call top-down mobilization. Top-down mobilization is mobilization that just starts from the top and then trickles down in terms of execution and application. And when you talk about top-down mobilization, you generally will be talking about legislation, where you put influence on the legislature to enact specific laws. And then there's bottom-up mobilization. Bottom-up mobilization is almost more, it's not as efficient, but the lawyer has better control of it in terms of its execution. And that is basically when you're talking about litigation, using litigation as a mobilization tool. The issue of wearing the hijab, for example, is one of these. Because obviously the Constitution talks about everybody having the right to practice, and not just for you to practice, but also to manifest your religion. The Constitution says it's a thing of pride to come to law school and manifest my religion, to go to anywhere and manifest my religion, to show that, yes, I'm from this faith. So the 1999 Constitution, for example, is almost a visionary in terms of the protection of religious rights. But again, there are people who are not of the same thought. There are those of us who will see the cross on somebody's neck and just be angry. Or the hijab over somebody's face and you think that he's different from us. That he must be crazy. It doesn't matter whether he's crazy or not. Those things are protected by the Constitution. And we have seen in terms of the hijab, for example, we have up to 4 or 5 cases now, right up to the Court of Appeal level in that regard. That is what you call bottom-up mobilization for social change, for the society to see things in a different way. Why? Because even the top-down mobilization is being ignored. I mean, the top-down, the legislation is being ignored. And the next thing is, one of the key things to do in terms of mobilization is how you devise disputes, the devising of disputes. how do you look at what you want to fight for? What test cases do you think you can develop in terms of going to court? If you are talking about the rights of women, for example, and a woman comes and says, I have certain rights in terms of gender. I'll give you an example. In the East, somebody said a woman couldn't inherit from her father. A daughter couldn't inherit from her father. And all the goods, all the inheritance will go to the male children. If FIDA, for example, is said to, that was the Federation of Women Lawyers, is said to be with people who have gender case inclinations, they look at some of those instances and then they think about how do we devise a dispute that is constitutional, that if we lose at the Court of Appeal, we can take to the Supreme Court. And they are not going to look at 20 cases. Other cases can be in court, but they are going to focus on a case that they think they can win. Why? Because the moment they win that case, it changes the whole social spectrum in the East in terms of inheritance. And not just in the East, it changes it everywhere in Nigeria. For everywhere, it becomes the ratio as the constitutional representation of that particular matter in case law. So the devising of disputes is absolutely important because you have to look at it from the perspective of this. There are 4 or 5 cases that are ongoing here. Which one can I win? Then you put all the focus on the one that you can win. The media focus is on it. The everybody is talking about that particular one case. There were hundreds of cases relating to LGBTQ rights in the US. But the most popular one is Oberfell. Because they realized that that was the whole foundation for rights in terms of same-sex marriage was grounded upon the facts in that case. Now, you divide disputes one by making strategic and tactical decisions at all times. The group sit down and they make strategic and tactical decisions. Brown versus Board of Education. Civil rights lawyers sat down, made tactical decisions relating to that. Ganifa Ami and INEC, same thing. Now, the second one is by influencing the direction of change processes. If it's important, you must advocate for the importance of that matter. Which means it must be in the forefront of either local, national, or international thinking. We talked about the LGBTQ rights, right? And I said, are we in Nigeria thinking about it more than other places? If we are thinking about it more than even the Americans or the British and other people, then that is the importance of influencing the direction of change processes. Why? Because in terms of elevating the matter, you are making other